Changes on Law and Social Transformation. My name is Siri Gloppen. I'm the Director of Law Transform. And it's my great pleasure to welcome you to this keynote by Jayna Kothari on gender, inequality, and the law. I will introduce Jayna to you shortly, but first I want to introduce the two commentators who are physically with us in Bergen. So it's Liv Tønnesen, who's Research Director at the Christian Michelsen Institute, the CMI, which is one of the owners of the Center on Law and Social Transformation. And the other is Henriette Sinding-Aasen, Professor of Law at the Law Faculty at the University of Bergen, which is the other institution co-owning the Law Transform. And both of you have been involved with the center since the beginning, so we're very, very pleased that you could be here. And so has Jayna Kothari. So we really, really miss having you this year at the exchanges, Jayna. You've been here many years before and always contributed in many, many ways. And this year, you will give the keynote for today. Jayna Kothari is senior advocate and practices at the Supreme Court of India, where she has argued many important cases, including the challenge to Section 3, which decriminalized homosexuality, and also the case decriminalizing homosexuality, and also the independent thought case, in which the Supreme Court recognized child marital rape as a criminal offense. So very, very important cases in this field of law. And Jayna is also the executive director of the Center for Law and Policy Research in Bangalore, where they do a lot of important work, both related to legal reform, but also litigation, including with the trans cell, where they do a lot of work relating to trans rights in India. And she's also a writer. We have her book on disability law in India, an academic and a writer, and it was published by Oxford University Press in 2012. So working in many different areas of law related to the topic today. So we are particularly pleased to have you talk to us this morning, Jayna. Please.
Thank you, Siri, and thank you everyone at the Bergen Exchanges for inviting me to be a keynote speaker. Having come to Bergen so many times and being part of the Bergen Exchanges physically, I really miss being there with all of you, and I'm glad that I'm at least having the opportunity to be there with you digitally and online. And share with you my keynote, and I hope to get some interesting inputs and feedback from all of you. So the topic, the panel topic is gender inequality and the law, and I thought I would speak in my keynote on what's happening in India, in the Indian Supreme Court on gender equality. I've titled my piece, my paper, tentatively, which is based on a recent paper that I've written, is the Indian Supreme Court cherry picking its gender battles? And that's the question that we're asking in India today on gender equality and gender inequality. So just to give an overview of what I'll be speaking on, recently, for those of you who've been following the developments of the Indian Supreme Court, the last few years have been very, very exciting. We would say that the Indian Supreme Court is really leading the way on gender rights. It has expanded in some of the recent decisions where Section 377, which was the criminal section which criminalized same-sex conduct, it decriminalized it and expanded the notion of sex discrimination under the Constitution to include discrimination on the basis of sexual orientation and gender identity. It passed the very important right to privacy judgment, where the court held that every person has the right to make decisions of, their most intimate decisions of their life, including their partners and people with whom they have intimate relations with, and that's part of the right to privacy. It has criminalized child marital rape in an important judgment. In India, we don't have the exception. Marital rape is not recognized as a criminal offense, but in the context of child marital rape, the court recognized it as a criminal offense. So many of these decisions on gender equality have been really, really progressive and exciting, and have kind of given the impression that the Indian Supreme Court really is moving towards promising, realizing gender equality in a way that wasn't done before. And so I interrogate this point. Has the Supreme Court really been doing that? And in my interrogation, I look at some of these recent decisions on gender equality, and I categorize them into three separate categories for the sake of analysis. And the first category is where the first category, I call it the easy cases, just for a discussion. And these are cases where gender equality judgments are given where petitioners are individual petitioners, or in cases of gender minorities like the LGBT groups, where a larger community is not affected. And I use the argument that there is no threat to the status quo. And I'll get into that as to what I mean by the status quo shortly. And I argue that in this first category of cases where the status quo is not affected, the Supreme Court has pronounced very progressively on gender equality. In the second category, the middle category, are those kind of cases which have an impact on marriage and family. And in these cases, the court has not passed very progressive judgments, or where it has passed positive rulings on women's equality, the court has made several caveats, or it has held back the full impact of its decisions. And the third category, and the final category, is what I call the hard cases, are where women's rights questions, or the questions of women's equality, are pitted against personal laws or religion, or the right to religion. And in these cases, in this category of cases, the court has not made decisions on the basis of gender equality at all. And I will take you through some of these decisions. And I argue that though on the face of it may seem that the Indian Supreme Court is being very positive and pushing the boundaries for gender equality, it hasn't done so, where it would mean that the status quo would be dismantled. And by status quo, I would refer to the situation where the inferior or unequal position of women or gender minorities in society are really destabilized, are shaken. It would be situations where within the religious framework or within personal law, the position of women is changed, and that would lead to a change in status quo. So these are the three categories, and I will take you through some of the decisions and the analysis of some of these decisions, and the directions in which the court has been ruling, and what has been guiding the court. Is it equality and gender, or are there other leanings? And we'll go through that. So I'll go to my first category, which is cases that do not affect the status quo. And these are cases of individual petitioners or sexual minority groups which do not have a larger impact on the status quo. And I take here two cases, and I'll try and kind of explain these in a little more detail if I have that time, because a lot of people may not be very familiar with the Indian Supreme Court decisions. So I'll just take you through some of these. So I look at two cases here, the Hadiya case and the Section 377 case. So the first case was the case of Hadiya. Hadiya was a Hindu woman who had converted to Islam and married a Muslim man. And she renamed herself Hadiya. And she had married her partner much against the wishes of her father. And after she married him, her father filed a petition for habeas corpus against in the High Court in Kerala to produce her, and also actually sought for her marriage to be annulled. Though Hadiya was a major, she was, I think, around 23 years old, a medical student, and he sought to be annulled, saying that she had a Muslim man and into converting to Islam. It finally went to court, and in the Supreme Court gave what actually was an extremely progressive judgment. Justice Chandrachud gave the decision, and the court actually relied on the right to privacy and held that Hadiya, as an adult woman, has the right to decide her own life partner, and there cannot be any restrictions in these rights. And I'd like to just quote a few lines what the court held. The court said that the Constitution recognizes the liberty and autonomy which inheres in each individual. This includes the ability to take decisions on aspects which define one's personhood and identity. The choice of a partner, whether within or outside marriage, lies within the exclusive domain of each individual. Intimacies of marriage lie within a core zone of privacy which is inviolable. The absolute right of an individual to choose a life partner is not in the least affected by matters of faith. So, these were very powerful lines in the judgment, where the court held that intimate personal decisions can be decided by the individual alone, even if it means going against, cannot be dictated by faith, cannot be dictated by family, or, even if there's no social approval. And in India, this becomes very important. So, the right to make intimate choices as falling under the right to life was upheld. And this was really, in the case of a Muslim woman. And so this was really seen as a big moment for gender equality. But at the same time, while the court upheld this right of Hadiya to marry the man she chose, the language of the judgment also includes the language of love jihad. The kind of love jihad argument has been actually quoted in some parts in the judgment. And by love jihad, I'm referring to the argument that Muslim men, this has been kind of a concept raised in India, that Muslim men, coerce Hindu women and tempt them into and marrying them and attempting to convert them to Islam. And so the argument of love jihad, though not upheld, was used. And at the same, while this case was going on, there was an investigation by a national agency, the National Investigative Agency that was ongoing, and looking into the so-called love jihad cases. So wherever there are cases of Hindu women marrying Muslim men and converting, these were seen as potential terrorist or terrorist acts, and the terrorism angle was being investigated. So interestingly, while the court upheld Hadiya's right to marry the man she chose, the court did not did not direct that this investigation into her case be stopped. And in fact, it held that the investigation could continue. So then it leads us to the question that, if this woman's right to marry her partner was upheld, then why was this investigation not halted? And the argument I also make is that this was seen as a big and important case of gender rights, but the language of rights and the language of the right to choose, the freedom to choose one's partner is using the language of the individual and not in the context of women's right to choose their partners. And I argue that there are in the Indian context, these are two very different rights. Men have always had the right to choose their partners in most contexts, but the same right is not equally available to young women. And though the case was about a woman, it was about the court could have used the language that women have the right to choose their life partners, even against family approval, but the court didn't choose these words, but kind of left it as an individual. So it became, I think, the impact of the case remains as an impact, as an individual rights issue, and kind of the impact, I would argue, it wasn't a larger impact. So that's about the Hadiya case. I move on in the same category to the Section 377 challenge, which was also a landmark decision. This was a constitutional challenge to Section 377, which criminalizes same-sex conduct. And in 2018, the Supreme Court passed a landmark decision upholding the rights to self-identify one's gender identity and the right to one's sexual orientation, and brought both these rights.
So I think maybe what we will do while Jayna is trying to log on again, even though we haven't heard all of her keynote, you've been able to read the chapter which is based on. So you have a disadvantage because you know what's coming. We don't know what's coming. We will hopefully know in a little while. But I was just thinking that instead of us just waiting to see what happened, that you maybe could give us some of your perspectives. Would you start, Liv?
Sure, I can start. But that's a disadvantage. But kind of at a disadvantage because I can't present the paper to you, so but I will try. So I'm not an expert on India, but I found that sort of the whole idea of religious freedom or religious law triumphing gender equality was a very sort of familiar story to me, strikingly familiar to my experience working in the Middle East and Northern Africa. Was that me? Oh, yeah.
No, I think it is Jayna.
Or she's back. Is she back? No.
So, I don't know. I'm not sure. Let me see.
Okay, I will just continue to talk until you tell me to stop. So in Sudan, where I have been working extensively, reforms within family law or personal status law has perhaps provoked the most resistance, especially from religious actors who perceive it as a threat to their sort of constitutionally granted authority over this field of law. So all sort of legal reform issues within that challenges religious doctrine in a way really creates like a pushback from these actors. So I found the paper very interesting, although empirically it was very foreign to my my comfort was not within my comfort zone, and I especially appreciated the attempt to create what I see as a potentially new typology of the Supreme Court's judgments on different types of gender issues. And I have mainly two. When she was lecturing, she was talking about different type of cases on gender equality. I see this as a proposal that there's like an issue distinctiveness in how the Supreme Court in India approaches cases related to gender equality. And this is a contribution to the recent scholarship on gender and politics, where there is where scholars are increasingly highlighting the need to sort of disaggregate gender equality. It's not like one-dimensional. And this is important because different categories of gender equality issues set in motion different actors, different cleavage lines, and also conflicts, potential conflicts. And one of the and this might explain, for example, why we see progress on some issues and not others in the Indian context and other contexts. So especially Mala Thun and Laurel Weldon, scholarship on gender equality policy seem relevant here. And they have developed a typology where they differentiate between gender status issues and class-based issues on the one hand, and doctrinal and non-doctrinal issues on the other hand, to sort of a four window typology. And one of the arguments that they make, and which I've already mentioned, is that, you know, all of these different issues that you can put into these boxes, they set in motion different cleavages and different conflicts. So as a name would entail, a doctrinal issue, often challenges religious doctrine, family law being one of them, and can sort of, especially in contexts where religious groups have political sort of institutionalized authority, create sort of a pushback from these groups because their authority is challenged. Meanwhile, for example, an issue like parental leave does not challenge doctrine and is not usually an issue that religious actors would care about. That has been, like, historically an issue that Labour parties and communist parties have advocated for, right? So different issues put in motion different actors. So I would have wanted to challenge the keynote to sort of further develop her typology on these issues and relate to that field. And I have one more comment, but yes, maybe
you can do that afterwards, because I don't know how much you heard of what Lee was saying, but we can have that discussion afterwards. We'll try again.
Okay.
See if we can have the link from here, from Bangalore, working again.
Okay.
Thank you, Siri. Thank you, Liv. I apologize for this disconnection. I don't know what happened, but I hope to continue. Yeah, sorry about that. So I was just on the issue of the Section 377 case and the LGBT case, and I would like to connect to some of the themes that Liv was also mentioning. Now, the Section 377 case was again a broad development on gender equality and discrimination on the basis of sex. The court even elaborated sex discrimination to include discrimination on the basis of sex or gender stereotypes. And that's a huge movement on gender equality under the Constitution. But here I argue that this was easy for the court to do. This was an easy case because this wasn't really a case where there was any pushback or backlash on these rights. Though we have quite a Hindu right government, the government did not oppose this judgment. In fact, the government did not even give file any objections to the case and allowed the court to kind of, pass its judgment. And I think, and the argument I make is that, LGBTQI rights on gender identity and sexual orientation are not a big threat to the status quo. The population, the LGBT population in India is still a small minority. The census records it as, just around 2%. They aren't a threat that is going to challenge gender hierarchies in Indian society. So it's really not something that either the government or would be worried about, or it's going to change or dismantle status quo in society in any way, within families, or, I mean, it can in individual cases, but not at a larger level. So this was really an easy case for the court to, pass this really progressive judgment. I go now to my second category of cases, which are the middle cases, which impact women's rights in within marriage and family. And here I'd like to take up again two cases. The first case is the independent thought case, and I'd be happy to share the links of some of these judgments if people are interested later on to read. So the independent thought case was a case where there was a challenge to the exception to marital rape in section 376 of the Indian Penal Code. So in the Indian Penal Code, our section on rape has an exception for marital rape. So marital rape is excluded from the offense of rape, and the exception is worded quite interestingly. It says that the section, where a woman is, the age of consent is 18, but the section 376 includes that it will, the exception to marital rape will only be where the wife is up to, it will not work where she's under 15 years old. So it allows for marital rape to be seen as an offense where the wife, a girl who's married, is under 15 years old. So thus also kind of condoning child marriage and accepting that it occurs. But otherwise, the age of consent is only 18. So this was challenged that since we have a law that prohibits child marriage and the age of marriage is 18, how can the criminal law not recognize any case of rape where there is sexual intercourse without consent, where a girl is married and is under 18? Now, in this case, there was a big pushback from the government. The government argued that if there is any intervention and if there is any attempt to recognize rape within marriage, even if it is for minor wives or minor brides, this would shake the very institution of marriage, because marital rape is not recognized in India. This would shake, this would mean intervening within the private sphere, and this cannot be done. And so there was a bit of a pushback because this does impact marriage and family. And this was actually rejected by the court. And Justice Madan Lokur, who passed the judgment, in fact, rejected the argument that any interference would destroy the institution of marriage, and went on to hold that within the ages of, up to the age of 18, even if a woman is married, she can, any sexual intercourse without consent would amount to rape, and the exception wouldn't hold. So on one hand, this can be seen as a huge kind of precursor, right, to a recognition of marital rape as an offense, and a great cause of celebration. But the judgment takes great pains to exclude many situations and not give it the full impact that it could. For example, one of the issues, one of the judges clearly says in the judgment, and I quote, that we make it clear that we have refrained from making any observation with regard to marital rape of a woman who's 18 years of age and above, because that is an issue which is not before us at all. Therefore, we should not be understood to advert to that issue even collaterally. So, the court kind of reiterated this point in many places in its judgment, that it should not be seen that it is actually speaking about marital rape of adult women. Even though the arguments that it used to criminalize child marital rape were based on, decisions of the UK House of Lords and other American Supreme Court judgments which recognized marital rape. So, it's rather odd. There are other parts of the judgment where the judges try and specifically say that they will not use the right to privacy arguments in this context, and they were not needed. And the right to privacy arguments made in the Indian context give very, very strong justifications to the state not interfering in the zone of intimacy or in intimate relations. And so it's rather odd that the court went to great lengths to make this caveat that the right to privacy, which guarantees autonomy in intimate decisions, that argument will not be relied upon, and refused to use that argument. So I argue that while on the one hand it recognized child marital rape, there was a great anxiety that the court had to ensure that its decisions do not impact the larger questions of marital rape, which would actually be very positive, which would be a very positive impact. There is a second decision in this category of cases. I will not go into that in great detail because I don't think we have too much time, but I will just give an overview of that. This was a case of Harsora versus Harsora, where the court made a broader interpretation to the Protection of Women from Domestic Violence Act. We have a domestic violence prohibition legislation, and it is a gender specific legislation which provides that complainants who can access the law can only be women. I know that in the larger context where trans rights also have to be expanded, unfortunately the domestic violence law was made around 15 years ago, and it does not include gender neutral application to victims of domestic violence. But what is also important in this case is that respondents, that is, persons against whom you can make complaints of domestic violence, respondents are adult males. The court, using the language of gender equality in this case, expanded this definition and said, well, if a woman is facing violence, it's in order to protect her and ensure that she's protected from violence in all situations, the gender of the respondents cannot be limited. So it cannot be restricted to adult males. It should be open to anyone. And it could be women, it could be minors who could be perpetrators of violence. This was, again, a judgment that was deeply criticized because the fear was that this broader interpretation made purportedly to protect women from violence, ignored all the empirical data there is that perpetrators of violence are usually men, or largely men, and would open the doors to misusing the law and to turn women against each other by making them respondents as well. So this was in the context of family and marriage. And the last category I would like to go to is how has, the cases where women's equality is pitted against religious and personal laws, and what has been the pattern of the Supreme Court in those kind of cases on deciding on gender equality. And in the last category, I would only like to discuss one case because this has been perhaps the most important judgment. This was the case of Shaira Bano versus Union of India. and this was the famous Triple Talaq judgment. So this was a case where the practice of Triple Talaq in India was challenged. Triple Talaq is a practice under Muslim law where the husband can divorce his wife by uttering talaq uh, 3 times continuously, and this practice of uttering talaq 3 times would result in a unilateral divorce to Muslim women. And this practice was challenged before the Supreme Court by women's rights groups, and the basis for the challenge was that it violates the rights of Muslim women, that it is gender unequal, it unilaterally allows men to give them a divorce, and that was it was a challenge that was founded on the fact that it was unequal towards women. The judgment, what is most surprising is that the judgment is overall favorable to women. So the court, by a majority decision, held that such a practice is unconstitutional and outlawed the Triple Talaq practice. But what is extremely surprising in this context, where the rights of Muslim women were right at the center of this question, was that the judgment was not based on gender equality at all. In fact, the judgment was based on completely different grounds. The court decided that the practice of Triple Talaq was not an essential part, or was not an essential practice of Islam, and therefore it could not be upheld. On the issue of equality, the court completely sidestepped women's right to equality and decided this on the principle of arbitrariness, that such a unilateral practice where the husband can pronounce talaq 3 times without any scope for reconciliation, not without a scope for the woman's voice, but without any scope for reconciliation of the marriage, was arbitrary, and such a practice could not be allowed. So, you know, the entire thrust of the court was in preserving the marriage, and the question of how Muslim women were unilaterally, at the receiving end of such a practice was completely ignored and sidestepped, and there was absolutely no finding on Muslim women's rights. In fact, I would just like to quote one para from the majority judgment. The court held that, and I quote, "Given the fact that Triple Talaq is instant and irrevocable, it is obvious that any attempt at reconciliation between the husband and wife by 2 arbiters from their families, which is essential to save the marital tie, cannot ever take place. It is clear that this form of talaq is manifestly arbitrary in the sense that the marital tie can be broken capriciously and whimsically by a Muslim man without any attempt at reconciliation so as to save it." So, you know, we see that the effort is emphasis on saving the marriage and not really looking at the rights of Muslim women. And so I'd like to kind of conclude here. And one of the observations has been that, in all cases in cases where women's rights or gender rights have been pitted against personal laws, courts have always sidestepped the question of women's equality in the Indian Supreme Court I'm talking about. And even where they have ultimately decided in favor of women, and I quote Catherine McKinnon, they do not ground their decision on doing so on gender equality. And that is the question I raise, that if the Indian Supreme Court is serious about gender equality, then it cannot tiptoe around difficult questions. And those difficult questions or difficult cases are cases where it's not just an individual, or it is not just rights where there isn't much of a backlash, or perhaps there is also a lot of social support, like LGBT rights. But those are the cases that are really hard, and the cases in which the Supreme Court has to take on gender equality head on are cases where they're pitted against personal laws, where they would shake the status quo in the family and marriage. And those are the cases in which the Supreme Court has to pass its decisions on gender equality, and do it not by sidestepping or tiptoeing, but do it in a strong and upfront way if it wants to show that it is a court that is really and truly gender just. So I'd like to end here, and I hope to get some thoughts from all of you.
Thank you. Thank you so much, Jayna. This was great and a lot of food for thought. I wonder if I will let Henriette go, and then you can take the rest of your comments afterwards. So I will let Henriette go now, and then I have a question from the chat that I will also read out, and we'll allow a couple of questions. We don't have much time, but because of the problems, we'll take a few more minutes. And of course, we continue with more of the same topic actually in the next session. Henriette.
Can you hear me now? No.
Yes.
Can you hear me? Okay. Thank you a lot for giving me the chance to reflect a little bit on these very important issues raised by Jayna, going really to the core of gender equality, and who are actually protected and how by the legal system, to the principle of equality and the task of the courts to secure gender equality. I would say to the question that is asked in Jayna's paper, to me it seems clear that the answer is actually yes. The Supreme Court is cherry picking its gender battles. And to me, it's not very surprising. Because, and this is a very general observation, that legal development usually is not very rational, completely rational, and principled. It is very often full of imperfections and even contradictions. And legal development is most often a slow step-by-step process where those kind of faults that Jayna correctly points out will or could hopefully be gradually corrected over time and after being challenged by clever lawyers like Jayna and others, and activists and the concerned public. If we look around the world, and we know that the combination of gender, family, and religion is an area where legal development is in a way particularly slow because of the many structural, value-based, private and personal changes that come along. This brings me to one other point concerning the Constitution of India. I don't know it very well, I must admit, but I believe, even if it's not a revolutionary, perhaps, constitution, still it is quite progressive. It claims justice, liberty, and equality for all, despite the very long history of inequality in India. Roberto Gargarella and other scholars have pointed out that constitutional reform may not be effective due to failure of taking into account essential power structures within the state and other areas, or within different structures in society when rights are implemented. And Jayna, in her paper, indicates a similar point. Powerful actors raise their voices, pointing out problems with a particular legal interpretation. And these can often be pragmatic points, such as the point of the Union of India saying that many girls under 18 were already married. And often they manage to impact on legal outcomes by these kind of arguments, because judges, they are also human beings, and they're often convinced by these arguments. Also partly because many of them belong to the same social class or group as those who resist the change of status quo. So this explains the long way from equality in the texts of constitutions to equality in real life, even when the cases are handled by Supreme Courts. And to me, it seems that the Indian Supreme Court made a conscious choice in the cases concerning marital rape. It did not want to explicitly give an opinion on adult women's right to privacy and autonomy. It was considered to be too much, probably, at the time. It was seen to be enough to ensure a much needed protection of the married girl child. I think it's really good to point out the limitations of this approach, the way Jayna does. The court could have been braver on behalf of all women. However, there are probably practical also reasons for the careful position of the court that I will briefly come back to.
But I think we actually need to close.
Okay, yes.
So because we're actually really running out of time.
Yes.
So I will let Liv take a few more comments,
Yes.
and then I actually think we need to stop. But we'll continue with some of the same issues in the next session.
Okay, thank you so much, Siri, and thank you so much for a very interesting presentation and paper, Jayna. So just a short recap of my comment when you were disconnected. I just want to, I really like, what I see as a potential typology, but would like you to challenge you to develop it further. So not only to establish, that the Supreme Court is cherry picking, but the pattern or the patterns in those judgments that you have already started. And it's related to my second comment as well. It's related to your concept of challenging the status quo, which I find very interesting and could also be a dimension of a potential typology. So the way I understand your presentation and read your paper, different gender issues provoke different judgments of the Indian Supreme Court. And especially those that touches on religious law, as Henriette also mentioned, and the family are perceived to challenge the status quo. So when I read the paper the first time, I read it as challenging unequal gender power relations in the sense that if women gain rights within the family, then men loses privilege, right? So in a family context. But it can also be read as challenging power balance within the state and interest of specific political and religious groups. So I think the concept can be used sort of as two-dimensional. So a specific gender issue can challenge sort of unequal power relations between men and women within the family. But at the same time, it could also challenge the authority of strong sort of interest groups. So my question to you is, could it be that, the case that the court is reluctant to progressively on certain gender issues is because they challenge religious doctrine, and it would provoke a pushback from religious groups within and outside of the state, not only sort of challenging male rights and privileges or making them feel like they're losing their rights. So I think you can use this concept in a dual meaning, but it requires you to bring in the political context to a greater extent, which, coming from a political scientist, and that would involve identifying like the different actors mobilizing for different type of women's rights or gender issues, and also identifying those actors that are potential counter mobilizers, because on the different issues that you set out of the different cases, the different actors are involved, which was the case, which was the main sort of essence of my first comment. Yes, so I will quit here because...
So this is really, really, really good. So I now realize, of course, like I always do, we have too little time. But the beauty of this is that I think we should schedule in about a week's time a new session where we can continue the discussion. We'll try and find a time that works for all, and then we'll just continue, because this was super interesting. And then we can do it as a webinar. Thank you. Thank you, Jayna, so much. Thanks to the people who wrote in the chat. So when we do the next session in a week's time, we'll include those comments. I've taken care of them. Thank you so much.
Thank you.
And once